Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a law point. Of course, it's not decided. Supreme Court has given notices to the other party. The point is whether it is unconstitutional to ask a person acquitted an offence to issue sureties to appear before the appellate court as per section 437A crpc. So now this is the problem. When a person is acquitted, normally he will be honorable acquitted. Even every bail bond will be dismissed. But please remember 437A says for making him appear before the High Court, the court will take bail bonds from him. This is as per 437A. We are going to discuss the section also. In the case of Ajay Varma versus Union of India and others, Ajay Varma versus Union of India and others in criminal appeal WP in writ petition criminal number 536 by 2023 on 6/11/2023, three judges bench, Honorable Chief Justice of India Dr. D.Y. Chandrachud, Justice Manoj Mishra and Justice J.B. Pardiwala. They took up the matter for consideration to discuss whether it is unconstitutional to require an acquitted person to give bonds under 437. Already we discussed in so-called Hussain Ara Khatun versus Union of India 1997 case, where it was highlighted that the persons have been languishing in jail for more than half of their sentence period. For example, if theft is punishable for 3 years, a person under remand, he is there for more than 3 years. So therefore, in the year 2006, if I am correct, an amendment has come for 438(6)A CRPC, 436A CRPC. That is, if a person has completed more than 50% of the sentence period while in remand, he has to be released on bail. Likewise, 437A, 437 you may be knowing that it deals with non-cognizable bail in non-cognizable offences. Fine. Here, 437A, so it reads like this. Before the conclusion of the trial, that means whether it is an acquittal or conviction, we don't know. Before the conclusion of the trial, the court shall, this is more important, the court shall require the accused to execute bail bonds, please remember, with some sureties to appear before the appellate court or higher court when that higher court gives notice. Otherwise, what happens? He may try to skulk away, he may try to get away. So that is the intention of 437A. This also came in 2009. Yeah. Act number 5 of 2009, this is also amendment. But the importance of the amendment is that he has to furnish surety to appear before the higher high court in case of appeal is there. If not, he can safely be at his home. Whether this is against the constitutional spirit or not. So Ajay Varma filed a criminal writ petition stating that section 437A is unconstitutional because when a person is acquitted, what is the purpose of his executing? Why he should execute a bond? That is the main reason. So please remember, this 437A, he has to execute bail bonds and they will be in force for I think 6 months. Right. So that means this provision makes compulsory that the persons to be released on even on acquittal, they should execute bail bonds with sufficient sureties. Now, Ajay Varma, on behalf of Ajay Varma, it was highlighted that there is a contradiction between 438A and 354D of the CRPC because 354D says The accused shall be set at liberty. No bonds, nothing. He can walk through the jail immediately after the acquittal. As stated in the case of Nannu and others versus State of UP. But please remember, here 437A says shall, that is more important. So it should be considered as a directive rather than a mandatory requirement. Right? Already Kerala High Court and Delhi High Court also, they have taken a positive view in this regard. Should be only directory but not mandatory. Right? Now, please remember, he says it not only violates the fund liberty as guaranteed by Article 21 of the Constitution, and it also, please remember, it poses obstacles for the release of the so-called acquitted person from the jail. That's why so many detentions more than the required period are occurring. Anyway, it is for the Supreme Court to decide. Very good topic. Honorable Supreme Court of India gave notices to the other parties. So after taking their opinion, after conducting the inquiry, then only they will be delivering some judgment. So very beautiful point. So whenever you think of 437A, you have to remember 446 also. What happens is, suppose if the person does not appear before the court within 6 months, as required by 437A, then his bond will be forfeited under 446 of the CRPC. So you have to remember all these legal points. These are very, very valid legal points. Practically, they come as obstacle. So you want, the case is acquitted, then you want him to take out. But if he fails to furnish the so-called sureties, he will not be let out. There the problem comes. And please read section 437A carefully, because before the conclusion of the trial, that is what is written in that section, before the conclusion of the trial, whether it is acquittal, whether it is conviction, but the court is direct, the court shall take bonds, because in the later part, he has to appear before the appellate court. So many people are getting out. Therefore, as a precautionary principle, they have introduced 437A in 2009. So, Supreme Court is going to discuss about the issue. Let us see what will happen. For the present, I am stopping. Thank you very much.